Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Today we are talking about will formation and execution as part of our Listen and Learn series. So let's start with the basics, like what is a will? A will is a document that calls for the disposition of a person's property upon their death. When someone dies without a will, their estate will pass through intestacy. Intestacy is where an estate passes according to the laws set by the jurisdiction. Many people execute a will so that they have complete discretion over where their property goes upon their death, because wills avoid intestacy. It is important then that a person creating the will, known as the testator, executes a valid will to ensure their wishes are carried out. What makes a will valid will depend on the jurisdiction. However, generally, a will has 5 elements. I'll go through each one of them one by one. First, to be a valid will, the testator must have the proper capacity at the time of execution. Proper capacity includes being both at least 18 years old and having sufficient mental capacity. The age requirement is a strict requirement because even if a person dies when they are over the age of 18, if the only will they have is one they executed while under the age of 18, the will is invalid. This means if a person executed a will at age 15 and died at 80, having never made another will, her estate would pass by intestacy and not the will executed when she was 15. Additionally, a testator must have the proper mental capacity. This means they must be of sound mind. Being of a sound mind is a pretty vague term. So what does that mean? Sound mind means that they can understand the nature and extent of their property, the nature of the disposition they are making with their property, and the names of and their relationship to the beneficiaries. Essentially, the testator needs to understand what property they own and who their property is going to. This capacity is measured at the time of execution of the will. Imagine that Sarah is 75 years old and executes a will, giving her house and car to her grandchild, Joe. If Sarah never owned a home or car in her life, she clearly did not understand the property she owned and would not be of a sound mind. Second, the testator must have testamentary intent. Testamentary intent means that the person intends the document to be their will and that it will become operative upon their death. Whether or not testamentary intent is present is a question of fact. An easy way to show testamentary intent is to include the words last will and testament in the document. Without a clear statement like this, other words in the will or extrinsic evidence can prove testamentary intent. Third, the will must be in writing. Oral wills, known as non-culpative wills, are not valid. This means a testator cannot record his will through a video or audio message. However, to satisfy the writing requirement, the will does not always need to be typed on sheets of paper. So long as the will is written, it satisfies this requirement. This means a will can be handwritten, etched into a wall, or carved into a rock. Fourth, the will must be signed by the testator. The signature requirement is pretty relaxed. Although it would be ideal, a signature does not need to be the testator's name written in cursive. A signature can be any mark that the testator makes on the will with the intent that it be their signature. It means a signed name, initials, an X, or even a fingerprint are enough to satisfy this requirement. Additionally, the testator is not even the person that needs to sign their name. Another person can sign the testator's name at the testator's discretion and in the testator's presence. The placement of the signature also does not matter in most states, just as long as it is somewhere on the document. Finally, if the will is multiple pages, the testator does not need to sign every single page of the will, because the will is a single document. All of this means that a valid signature could be the testator signing their full name, or it could be the testator telling his daughter to sign his initials, on the last page of a multi-page will. Fifth, the signing of the will must be attested by 2 competent witnesses. In UPC jurisdictions, this requirement can be replaced if the will is signed by a notary. The attestation requirement can be complicated, so let's break it down. The witness must be competent, meaning at the time the will is executed, the witnesses understand what they are doing and could testify in court on the situation if necessary. The majority of states also require the witnesses to be disinterested. A disinterested witness is someone who does not take in the will. If the witness is interested, their bequest from the will is purged or void. A minority of jurisdictions and the UPC do not have this prohibition, and interested witnesses' bequests are not purged. As an example, imagine Frida executes a will leaving her car to her son Doug. Doug serves as one of the witnesses. In this situation, Doug is an interested witness because he is set to take in the will. In the majority of jurisdictions, Doug's bequest in the will would be purged, meaning he would not take the car upon Frida's death. In the minority of jurisdictions and UPC jurisdictions, Doug's bequest would not be purged and he would still take the car at Frida's death. The final consideration for the attestation element is that the testator must sign the will in the presence of 2 witnesses. There are 2 approaches to what presence means. The majority approach follows the conscious presence test, where the presence requirement is satisfied if each party has a general awareness of where the other parties were and what they were doing when the testator signed. An example of this would be if the testator signed his will while in a hospital room behind a curtain. Under the conscious presence test, a witness standing in the doorway and unable to see the testator behind the curtain would satisfy the presence requirement. The minority of jurisdictions follow the scope of vision test. This means the witnesses must actually watch the testator sign the will. So standing in the doorway while the testator is behind a curtain would not be enough to satisfy this test because the witness can't see the testator at the moment of signing. Now, that was a lot of information, so let me summarize it for you. A valid will has 5 elements. First, the testator must have the requisite capacity, meaning they are of age and have enough mental capacity to understand what they are doing. Second, the testator must have testamentary intent. Third, the will must be in writing. Fourth, the will must be signed by the testator. And finally, the will must be attested by 2 witnesses, meaning the testator signs the will in the presence of 2 people with the capacity to understand the situation. There is one popular variation of a typical will called a holographic will. A holographic will is one written by the testator in his own handwriting. A holographic will requires the same elements I talked about, except for the attestation requirement. To be a valid holographic will, the testator must have capacity and testamentary intent, and the will must be in the testator's own handwriting and be signed. This type of will is allowed in UPC and the majority of other jurisdictions. So let's work through a hypothetical together to see how well you understand the creation of wills. This hypothetical is adapted from the July 2021 California bar exam. In 2016, while single and living in state X, Hank downloaded a will template and filled it out stating, "Because I have no children, I leave all my property to my brother Carter when I die." Hank signed his will in the presence of 2 disinterested witnesses. In 2017, while still living in state X, Hank married Wendy. A daughter, Carly, was born to Hank and Wendy in 2020. In 2021, Hank started a new job. On the first day of his job, he suffered a fatal injury. Is Hank's will valid? Well, what do you think? Remember that to be valid, 5 requirements must be satisfied: capacity, testamentary intent, writing, signature, and attestation. To see if Hank's will is valid, we need to consider each of these elements. First, Hank seems to have the proper capacity. The facts do not tell us his age, but we will assume he is at least 18 years old. Hank also seems to be of sound mind because he understands his property and the nature of the disposition because he is leaving all of his property to his closest relative, his brother. Second, Hank seemed to have testamentary intent. He chose to download and fill out a will template, and he indicated who he wanted his property to go to upon his death. Third, the will satisfies the writing requirement. Although it is unclear from the facts whether Hank typed the will provisions or printed out the template and hand wrote the provisions, that should not matter because the majority of jurisdictions allow for holographic or handwritten wills. Finally, to satisfy the fourth and fifth elements, the facts tell us that Hank signed the will in the presence of two disinterested witnesses. This means that because all 5 will requirements are satisfied, Hank executed a valid will. So let's try another. This question is adapted from the July 2006 California bar exam. In 2003, Tom, a patient at Happy Home, a hospital that specializes in caring for the disabled elderly, asked Lily, his personal assistant, to help him execute his typewritten will. Tom suffered from severe tremors and had difficulty signing his name. In the presence of Lily and one other attendant, Tom directed Lily to sign his name and to date his will. Lily did so. At Tom's request, Lily and the other attendant signed their names as witnesses. The will stated, "I give $100,000 to my niece, Nan. I give the rest and residue of my estate to my personal attendant, Lily." In 2005, Tom died, leaving an estate worth $1 million. Did Tom execute a valid will? To see if Tom executed a valid will, we need to see if the 5 requirements are satisfied. First, Tom had the proper capacity. Being that he was in an elderly care hospital, he was over the age of 18 when he executed the will. Tom is also of sound mind because he had awareness of the amount of money he owned as well as knowledge of who he was giving his property to. Although Tom was in an elderly care facility, the facts do not tell us anything about his mental condition. We can assume then Tom did not suffer from any mental disabilities that would impact his capacity. Second, Tom had testamentary intent because he asked Lily to sign his will. This shows he intended this document to be his will. Third, the document was in writing because the facts tell us it was a typed will. Fourth, the will was signed. This element is satisfied even though Tom himself did not sign it because the testator does not have to be the person who signs their name. Lily validly signed the will for Tom because she did so at Tom's direction and in Tom's presence. Finally, the attestation requirement is satisfied. The will was attested by 2 witnesses, Lily and another attendant. The only issue is that Lily is an interested witness since she is a beneficiary of the will. In the majority of jurisdictions, this will purge Lily's gift of the residue. In the minority of jurisdictions and in UPC jurisdictions, the fact that Lily was an interested witness will have no effect on Lily's gift, and she will still be able to take the residue upon Tom's death. Either way, the requirement is satisfied, but Lily may or may not be able to take, depending on the jurisdiction. Overall, then, Tom executed a valid will because all 5 elements are satisfied. What happens, though, if someone made a mistake while creating the will? Imagine you are representing a client in creating their will. After multiple conversations with the client, you draft up a will and email it to them. Your client emails you back that the will looks great. Annie will come to your office tomorrow to finalize the execution. Unfortunately, on the way to your office, your client is in a car accident and passes away. Would your client's estate pass through intestacy? Or would a court excuse the will requirements that were not satisfied? Well, most states demand strict compliance with these 5 requirements. However, some states will still consider a will valid through the harmless error rule if a mistake is made. These states will excuse a harmless error if there is clear and convincing evidence the testator intended that the document be a will. Generally, courts will use the harmless error rule to excuse minor mistakes with the attestation and signature requirements, but not the writing, capacity, or intent requirements. So in this situation with your client, it will depend on the jurisdiction. If the jurisdiction demands strict compliance, your client's estate will pass through intestacy. However, if the jurisdiction follows the harmless error rule, the court will likely uphold the validity of the will. There is clear and convincing evidence that the client intended this draft to be his will, because his email said that the will looked great and he would be in tomorrow to finalize the execution. All right, well, that's a wrap for today. Glad you could join me as we discussed will formation and execution. If you enjoyed this video, be sure to give us a like, leave a comment, and subscribe so you don't miss any future content. Also, check out more bar content at barexamtoolbox.com.